the case that could rewrite gun laws forever. For almost a century, the Second Amendment battlefield has been fought on the same old lines. Politicians pass new restrictions, courts rubber stamp them, and gun owners are left wondering if the right to keep and bear arms is really a right at all, or just a privilege dressed up in constitutional language. But something historic is happening right now. The Supreme Court's 6-3 decision earlier this year didn't just tweak the rules. It cracked open the foundation of how courts evaluate gun laws, and the ripple effects are building into a tidal wave. For the first time since Bruen, the justices are being asked to answer a question no one thought they'd touch. Can the government keep banning ordinary firearms and accessories when history, text, and tradition say otherwise? Legal experts are calling this case the biggest 2A fight since Bruen, and they're not exaggerating. The ruling is already sending shockwaves through California, New York, Illinois, and every other state with restrictive laws. On Survival Firearms, we break down these fights with clarity and precision, because these aren't just abstract court battles. They decide how you, your family, and millions of Americans live day to day. So, in this video, here's what we'll cover. Why the Supreme Court's ruling is unlike anything we've seen since Bruen. The backstory of the case and the law it directly challenges. How the history and tradition test is reshaping every courtroom debate, what this means for lawful carriers in restrictive states, and why this fight could permanently change the future of the Second Amendment in America. This is not just a story about laws. It's a story about rights, power, and whether freedom really means freedom. Let's dive in. Chapter 1. From Bruen to the Breaking Point. The story starts in 2022 when the Supreme Court handed down New York State Rifle and Pistol Association versus Bruen. That case changed everything. Before Bruen, states had enormous leeway to defend restrictions under a vague concept of public safety. Legislatures could claim that limiting carry rights made cities safer, and lower courts almost always deferred to that reasoning. But in Bruen, Justice Clarence Thomas rewrote the rulebook. Instead of asking if a law seemed reasonable or helpful, the court declared a new standard. Any modern gun regulation must align with the text of the Second Amendment, supported by historical tradition from the founding era. That meant no more balancing tests, no more broad deference to legislatures. If the founders didn't have a law banning it, modern governments can't ban it either. This was a revolution, and immediately states like California and New York scrambled to rewrite their carry laws, adding massive lists of sensitive places and piling on new restrictions. They were gambling that if they threw enough complexity into the system, the courts would take years to sort it out. But here's the problem. Bruen set the bar higher than anyone realized. And that brings us to the new Supreme Court ruling, a decision that proves the old ways of defending gun laws simply won't survive anymore. Chapter 2. The case that shook the system. The case at the center of this storm is simple on the surface, but explosive underneath. At issue was a state-level restriction that rationed firearms purchases, limiting law-abiding citizens to a set number of purchases per month. California pioneered this rationing model with its infamous one gun per 30 days law, later echoed by states like New Jersey and Virginia. The logic was shaky from the start. Legislators claimed it would reduce trafficking and straw purchases. But there was a glaring problem. No historical precedent. The founders never imposed purchase quotas. No clear evidence that it worked. Traffickers don't follow legal purchase limits, and yet courts upheld these laws for decades. That ended when the 6-3 Supreme Court ruling came down. The justices didn't just strike at the surface of rationing laws, they dismantled the reasoning behind them. Their message was blunt. The government cannot ration constitutional rights, period. This was the first time the court explicitly drew that line in modern Second Amendment jurisprudence. And it's why many experts say this is the most consequential ruling since Bruen. Chapter 3. Why the history and tradition test matters. At the heart of the decision lies the Bruen test. Text, history, and tradition. The court used it like a scalpel. The ruling spelled out 3 key principles. Text comes first. If the Second Amendment protects the right of the people to keep and bear arms, then any law that restricts that right is presumptively unconstitutional. History is the filter. The government must point to relevant, historical laws from the founding era that justify a modern restriction. Tradition defines scope. If no tradition of similar restrictions exists, the law cannot stand. California tried to argue that rationing purchases was a modern version of historical limits on stockpiling or militia regulations. The court wasn't buying it. The justices noted that in the 18th and 19th centuries, citizens were often required to own arms, not restricted from buying them. This test is more than legal theory. It's a wrecking ball aimed at decades of creative gun control laws. Anything not rooted in history is now on the chopping block. Chapter 4. California's model collapses. California wasn't just defending its own law, it was defending a model that many other states have been copying. The idea of rationing, whether 1 gun a month or 3 guns every 90 days, spread precisely because California courts upheld it. Legislators in other blue states looked to Sacramento as their shield, but when the Supreme Court struck it down, that shield shattered. Here's what it means in practice. California's 1 in 30 law is unenforceable. New Jersey's restrictions face immediate legal challenges. Virginia's carry rationing, reinstated in 2020, is now under fire. Other states considering similar laws are backing away, knowing they won't survive judicial review. For years, California's strategy was to pass laws faster than courts could strike them down. But this time, the court sent a warning. The days of endless experimentation are over. Chapter 5. The National Ripple Effect. This ruling isn't staying in California, it's exploding outward like a shockwave. Already, attorneys are citing the decision in challenges to assault weapon bans in Illinois and Maryland lack historical analogs, magazine capacity limits in New Jersey and Colorado, sensitive place laws in New York and Hawaii, which attempt to ban carry almost everywhere. The Supreme Court just gave challengers the ultimate weapon, precedent. If rationing laws can't survive because they lack historical support, why should bans on common rifles or accessories? Legal scholars call this the domino effect. Once one pillar of modern restrictions falls, the rest begin to topple. And right now, that domino chain has only just begun. Chapter 6. The Courtroom Chess Game. When a ruling like this lands, the first reaction from state governments is not surrender. It's strategy. California's Attorney General immediately began signaling new workarounds, hinting that they might tweak the language of restrictions and try again. But here's where the Supreme Court's clarity matters. Unlike older rulings that left gray areas, this decision was written to be airtight. Key takeaways from the courtroom. The justices said rationing rights has no precedent in American history. They warned lower courts that they must stop inventing new justifications. They set a roadmap for how future challenges should be analyzed. For once, the court left very little wiggle room. That means state attorneys are playing defense, not offense. And every failed attempt to rewrite a struck-down law only builds stronger precedent for gun owners nationwide. This isn't just a legal skirmish, but it's a chess game. And right now, the pro-Second Amendment side just moved its queen into play. Chapter 7. The dominoes start to fall. History shows that once one precedent shifts, others begin tumbling in quick succession. Already in motion, Illinois, its sweeping assault weapon ban is being challenged using the same reasoning. If the court says you can't ration purchases, can you really ban entire categories of common firearms? New Jersey, their post-Bruen carry killer bill, packed with dozens of new sensitive places, is hanging by a thread. Courts are directly citing this ruling to question its survival. Hawaii, judges are openly skeptical about laws restricting where permits apply, pointing back to Tennessee's precedent on public spaces. Each of these is a domino, and once enough fall, the entire wall of modern restrictions starts to collapse. Why this matters? This is no longer about isolated victories. The structure of post-Bruen law means every ruling reinforces the next. Momentum is real, and it's accelerating. Chapter 8. The Counterattack. Of course, victories don't end the war, they shift the battlefield. Almost immediately after the Supreme Court's ruling, legislators in states like California and New York began drafting new bills. The strategy is simple. Rewrite the struck-down law with slightly different language. Rebrand restrictions as public safety measures. Hope courts take years to sort it out. For example, California's AB 1078 tried to replace its 1 gun per 30 days law with a 3 guns per 90 days rule. Same concept, new packaging. New York added entire city blocks to its list of sensitive places after Bruen gutted their old law. But here's the catch. Every time they do this, they risk losing even more ground, because Bruen's framework doesn't allow endless reshuffling. History either supports the law or it doesn't. And when politicians keep writing laws that fail the test, they risk not just losing battles, but losing credibility with the courts themselves. Chapter 9. Beyond the Second Amendment. Here's where things get even more interesting. This fight isn't only about the Second Amendment anymore. The reasoning courts are using, that rights can't be rationed, that restrictions must be rooted in history, is beginning to echo in other areas of constitutional law. Implications. Fourth Amendment. Just as the court rejected moment of threat analysis in excessive force cases, it is now rejecting arbitrary rationing of rights. Together, these rulings build a stronger shield for individual liberty. First Amendment. If you can't ration gun rights, can you ration free speech? Can the government say you can only protest once a month or publish a limited number of articles? This logic suggests not. Due process. By demanding historical grounding, courts are forcing legislatures to defend every law with real, provable precedent. No more modern policy goals as justification. This is why legal scholars call it a constitutional realignment. It's not just about firearms, it's about pulling power away from legislatures and giving it back to the people. Chapter 10. The Dawn of a New Era. For 134 years, the Ninth Circuit was known as the graveyard of the Second Amendment. Cases went in, and rights came out diminished. But today, the tide has turned. The Supreme Court's ruling marks the dawn of a new era, one where text, history, and tradition is not just theory, it's the law of the land. One where restrictions cannot hide behind vague appeals to safety. One where citizens finally have the courts on their side, not stacked against them. Tennessee, Minnesota, Washington, California, these are just the first fronts. The battles ahead will reshape every corner of American life, and if history tells us anything, it's this. Once courts consistently enforce rights, freedom expands faster than anyone expects. Think about it like this. For 90 years, the NFA shaped how the government treated gun rights, and today we're seeing the first real cracks in that wall. But here's the truth. This battle is just the beginning. The lawsuits are live, the politicians are scheming, and the courts are staring at questions they've dodged for a century. So here's what I want you to do. Stay in the fight with us. Don't just watch, share this video so more people understand what's at stake. Drop a comment below. Do you think the NFA's collapse is inevitable, or will Washington find a way to glue it back together? Most importantly, subscribe to Survival Firearms, because in our next breakdown, we'll cover the one case that legal insiders are calling Bruen 2.0, a challenge so explosive it could rewrite not just the NFA, but the very definition of the Second Amendment itself. Stay aware, stay prepared, and remember, every right you hold today was once fought for yesterday. We'll see you in the next one, and trust me, you don't want to miss it.